So good evening, Amisha.
Good evening, ma'am. Good evening, sir.
Good evening.
Can you please introduce yourself, Amisha? Your
Yes.
law school, your background, and also share your experience that shaped your decision to appear for the Judicial Services examination.
Yes, ma'am. Of course. Ma'am and sir, I hail from Panipat, Haryana. I have done my schooling from Panipat only. In 2018, I got myself enrolled in UPS Dehradun for BBA LLB. I stayed there for 5 years. Throughout my graduation, I was consistent and hardworking, which rewarded me by my college by silver medal in academics for achieving first rank. After completing my graduation in 2023, I moved to Delhi for dedicatedly and disciplined study for judicial services. Ma'am, in my throughout my preparation journey, I was consistent, hardworking, balanced with the smart working. My in my family, I have my father, mother, and my younger sibling who is still studying. From my 12th class only, I was dedicated and I had this thing in my mind that I want to become a judge one day. In 12th class, I started taking coaching for for CLAT entrance examination and for LSAT entrance examination. And when I stepped into my college, into my graduation, I was determined that I have to become a judge one day. And I was studying for that perspective only.
What motivated you to become a judge? Like, what was that 12th standard में ऐसा क्या हुआ कि आपने उसी time decide कर दिया that I want to become a judicial officer?
Ma'am, primarily it was my father's thing that he wanted me to become a judge. And when I started studying that thing, it gave me a lot of new motivation within myself to become a judge. When I started studying and when I started seeing how respectful and stable life judge possesses, I thought that I want to do that one day because with that stability and respect, I could even learn and explore more every day, which is the interest area of myself. So yes, both the personal and external factors help me and push me towards this goal.
Okay. So do you know that even the judicial officers they get posted, so it's never
Yes, ma'am.
stable, है ना? तो
Yes, ma'am.
stability तो कम ही है, but फिर
Yes,
भी
ma'am. Ma'am, I agree that there is no stability as to the geographical limits, but there is a stability of a career choice. I was never restricted myself with the geographical errors and geographical limits since I have moved states for my graduation and then for appearing for learning for judicial services. So geographical limits or the posting thing doesn't bother me.
who has been your biggest role model in law or outside law, and why?
Uh, yes, ma'am. Ma'am, since if I talk about in my personal life, my biggest role model was and is my father since always. He is the one who always motivates me, helps me, supports me in every up and down, which an aspirant faces in their preparation journey. If I, with due respect, if it is in my professional career, the I haven't looked too much into the role model thing yet, but which I am thinking I should have a role model. But I do admire and adore the job which is done by Justice B.R. Krishnan Iyer ji, past in its time, and it's his judgment which settled the presidential value in our system. I adore it a lot.
Can you give us any one judgment from him?
Yes, ma'am, of course. Ma'am, I'll not mention any particular judgment about him, but the work he has done with Justice P.N. Bhagwati sir was amazing by introducing the public interest litigation system in our society, which is a high demand of the hour, which is which is the foundational rule for serving justice to the society. And yes, the judgments like he has given it for education related purposes and the Menka Gandhi judgment also.
What is his full name?
His full
Justice
name is Honorable Justice Venkatarama Venkatarama Krishnan Iyer Krishnan Iyer.
Vekum Purushottam Ramakrishna Iyer.
My
Justice
apologies.
B.R. Krishna. Yes. Okay. All right. Yes, over to you, sir. Ravi, sir.
Okay. Amisha, recently you have stated about the judgment of the Honorable Supreme Court of India. So I just wanted to know what is the qualification to be appointed as the judge of the Supreme Court of India?
Sir, with due respect, the judges of Supreme Court are appointed by Article 124 of the Constitution by the President. So they have the qualification like they can be an expertise jurist or a judge in High Court or standing advocate for particular time period. So yes, sir, these are some qualifications for
And
being a
what is
judge.
that particular time period, Amisha?
Sir, in my humble opinion, I couldn't relocate the actual time period, but somewhere it is like 10 years of experience as a standing advocate in High Court and 7 years or 5 years of being judge in High Court.
Okay. Amisha, what is the difference between the regular bail and the anticipatory bail?
Yes, sir. Sir, the regular bail, which is given in bailable offences as stated under Section 436 of CRPC, Code of Criminal Procedure, here the bail is the right and not the discretion of the court. Sir, the general rule that is bail is rule and jail is exception, which was laid down by our very fundamental and presidential case laws, states that that is a case of regular bail where the accused person gets a bail as a right. Whereas in anticipatory bail, there is not even it is not compulsory that FIR must be registered, but it could be given on mere apprehension of the person on a recent order that he is apprehending his arrest and needs the bail from the court.
To suppose, Amisha, if anyone who has a real apprehension that person might be arrested at any moment of time, but the main thing is that still the FIR has not been lodged. So how will you justify yourself that there is a real apprehension regarding the arrest of that person?
Yes, sir. Sir, in that scenario, when the person is mere apprehending, he could establish the circumstances and the uh, the circumstances which made him believe that the FIR could be registered against him. By proving all the circumstantial evidence, by proving through the circumstantial evidence and through the situations or case laws or the controversy which may go against him, he could uh, prove the court and ask from the Honorable Court to have the anticipatory bail.
Amisha, what is the literal interpretation of the word of ratio decidendi and obiter dicta?
Yes, sir. Sir, ratio decidendi means which is the reason of the court. Obiter dicta means what was the status of the court. Sir, in our in the judgments which we use as a presidential judgments, we use the ratio decidendi, the reasons of the judgment, the reason of the decision, not generally the obiter dicta. Obiter dicta can be used as aiding of the judgment, but the ratio decidendi has been the fundamental thing of precedents.
हमेशा ये बताइए कि रिसेंटली सुप्रीम कोर्ट ने एक बात को कंप्लीटली क्लियर कर दिया है कि इफ यू आर विलिंग टू बी अ जुडिशियल ऑफिसर देयर मस्ट बी अ मिनिमम प्रैक्टिस ऑफ 3 years. आप इसको किस नजरिए से देखना पसंद करती हैं?
Yes, sir. Sir, in my humble opinion, I totally respect the judgment which is given by our Honorable Supreme Court. So if the honored and respected judges have given such judgment, they must have ensured all the prospective aspects and circumstances which made them give such a huge judgment, which shaken the uh, life and career of many of the aspirants. But sir, their perspective is good is from the perspective of the judges that the person should have a practice experience before coming into the actual court. Whereas on the other side, if we see that, in my humble opinion, since 2010, the practice since 2000, it has been going on that you can freshly enter into judiciary. So maybe because of the cases and the decision which is passed by the young judges, uh, they were disturbed. But sir, in my opinion, there could be an alternative like giving the trainings and assist them could be an option. But whatever our Honorable Supreme Court has given, I totally respect it and I totally admire their judgment and reasons.
Okay. Amisha, ये बताइए, when a woman she is looking for the amount of the maintenance, so usually they should go with the concept of either 125 of CRPC or the 144 of the BNSS. But if we talk about the concept of the interim maintenance, so usually what kind of remedies or the alternative paths you have?
Yes, sir. Sir, interim maintenance has primarily used under 125 CRPC and 144 BNSS. So, sir, firstly, the meaning of the interim maintenance is the maintenance of through for the time being till the actual orders comes. So they are seeking for the interim maintenance. Sir, from the Hindu law perspective, Hindu Marriage Act Hindu Marriage Act talks about the maintenance which the wife could seek from his husband. Sir, in that also there is a provision of interim maintenance, which is called lis pendens during the litigation, seeking the litigation expenses from the husband. Also, sir, Section 18 of the Hindu Adoption and Maintenance Act talks about the maintenance from the husband into various circumstances. And sir, also as per the Protection of Women from Domestic Violence Act, she can see the different kind of orders from our honorable court, like protection order, custody order, compensation order. Also, that protection order could be interim, which means during the period of the litigation till the actual order comes from the court.
Amisha, recently there is a concept which has been introduced under the provision of the BNS that is called organized crime. Have you gone through the concept of organized crime, OC?
So, in my humble opinion, I haven't studied into a depth, but I saw that there were introduction of new crimes into Bharatiya Nyaya Sanhita, like
Okay.
terrorist act, organized, and they bifurcated crimes into different categories with the aim to resolve it quickly and to have the speciality of the crimes and to treat them into more depth and with more clarity. But sir, I'm not very much aware about its procedure and its terminology right now. But I'll
Okay.
surely look upon this.
Amisha, there has been a word which has been mentioned in the Act of POXO, which deals with the offenses against the children, and the name of that word is called aggravated. So I just wanted to know कि what is the exact literal interpretation of the word of aggravated? क्या मतलब होता है इसका?
Yes, sir. Sir, there can be an offense. There are different kind of offenses which are listed under POXO Act. So there could be an offense which is simple, or there can be an offense which is aggravated. So, sir, there are circumstances listed down under the provision which states that when the offense could be aggravated. For instance, sir, if there is a gang rape or if there is a rape of a woman who is pregnant or who does it repeatedly over the woman, that makes it aggravated. Yes, sir, the committal of rape is itself an offense, but committal of rape over a woman who is pregnant or repeatedly on the same woman makes it aggravated form. So, sir, the major difference lies in the degree of the offense itself.
Okay. अगर मैं आपसे बात करूं लिव इन रिलेशनशिप की, तो क्या इसके अंदर भी a woman can seek the maintenance? And if yes, so usually on what ground?
Yes, sir. Sir, it is not expressly stated anywhere in the code that women in living relationship could seek maintenance, but as per the recent judgments and various judgments by our Honorable Supreme Court and High Court of different states, it is clear that live-in partner could also claim the maintenance from the partner. Recently, in case of Lalita Tupu versus State of Jharkhand, the Honorable Supreme Court listed down various factors on which the women could claim maintenance from the living partner. These factors were if they were living together for a very long time, they're eligible to get married, the people take them as husband or wife, they were living as a husband and wife for over a long time, and they were treating it like a real relation, and they were not barred from marrying as per their laws. So in that scenario, they can claim maintenance.
Okay. What is your opinion over the concept of muta marriage under the Muslim law?
My apologies, sir. I'm not very much aware about Muslim law right now, but I'll surely look into this.
Okay. Have you gone through the concept of law of tort?
Yes, sir.
What is defamation?
Sir, defamation can be civil or criminal, which is also which is stated in torts as well as code of which is stated in Indian Penal Code as well. Sir, when someone does any act by written, by sign, or by any publication to harm the image, reputation of the other person into the society, that is called defamation.
ओके, कॉग्निजेबल ऑफेंस से आप क्या समझती हैं? संज्ञेय अपराध.
Yes, sir. Sir, in my humble opinion, cognizable offenses means are those offenses in which the police can arrest the person without the warrant of the magistrate. Another thing is, sir, in the cognizable offense, the investigation is done by the police officer even without directing by the magistrate. Sir, these are the kinds of offenses which are generally serious in nature, in circumstances which are punishable with imprisonment of 7 years or more, or maybe less, but the police officers have the reason to believe or the information that the offense has been actually committed. So these are kind of serious offenses as compared to non-cognizable offenses.
अमीशा, रिसेंटली आपने एक शब्द का जिक्र किया है, दैट इज कॉल्ड पनिशमेंट्स. So either in IPC or the BNS, there has been a provision of life imprisonment and it contained literal 3 interpretation differently. What were those?
Yes, sir. Sir, life imprisonment is one of the imprisonment which is rigorous in nature. Sir, there may be an instance where the people, laymen, or the court could interpret life imprisonment as the imprisonment till the remaining life of remaining natural life of the accused or the convicted person. It could be interpreted into 14 years as per stated in our Indian Penal Code, or it could be taken as 20 years when it has to be commuted into 14 years of imprisonment. So, sir, the interpretation for life imprisonment has been varied by from case to case.
Okay. बट अगर हम 20 साल की बात करें तो आपको क्या लगता है ये 20 साल यूजुअली किन किन जगहों पे यूज किया जाता है?
So, as
क्योंकि
per
देखिए
as
अमीशा, 14 साल का मतलब तो ये है कि द स्टेट गवर्नमेंट, इफ ही और शी और स्टेट गवर्नमेंट इज विलिंग टू रिलीज that person will not release until the competition will not be held minimum 14 years. जब तक 14 साल पूरे नहीं हो जाएंगे that person shall not be released. ठीक है, पहली बात. बट ये जो 20 साल है जिसको हम एज ए फ्रैक्शन के रूप में कैलकुलेट करते हैं, आमतौर पे ये किस सेंस में यूज किया जाता है? मेरा ये सवाल है आपसे.
yes, sir. Sir, generally, wherever it is written that the person, the convicted person will be punished for life imprisonment, it is interpreted as 20 years only until or unless the court itself states expressly that it is till the remainder of the natural life of the convicted person. So, sir, the general interpretation of life imprisonment is 20 years only unless the court itself bars it, extends it to the remainder of the life.
ओके. अमीशा, अगर मैं आपसे कॉन्ट्रैक्ट की बात करूं तो व्हाट आर द एसेंशियल्स ऑफ द कॉन्ट्रैक्ट?
Yes, sir. So, as per Section 10 of Indian Contract Act, which is the backbone of the Indian Contract Act, states that there must be a valid agreement which must be for lawful object, lawful consideration by the lawful people who are competent to contract. So, sir, these are the foundational essentials. Other than that, the consideration must be legal, must not be immoral or illegal, and that is must by the people who are competent to contract, which means as per Section 11 of Indian Contract that they must be major, not unsound mind or disqualified by the law.
Amisha, which amendment of the Indian Constitution is considered as the mini constitution? भारतीय संविधान का वो कौन सा संशोधन है जिसको कि आमतौर पे एक मिनी संविधान या सूक्ष्म संविधान की भी संज्ञा दी गई है?
Yes, sir. Sir, it is 42nd Amendment of the Indian Constitution.
उसमें कितने अमेंडमेंट्स हुए हैं? क्या आप किसी का जिक्र करना पसंद करेंगी?
Yes, sir. Sir, the major and the foundational amendment was in the preamble where the word sovereignty was added, and it completely changed the our constitution as it added the very important words in the preamble. Other than that, there were introduction of various various directive state principles as well, like section Article 39A, providing legal aid to the people and ensuring that the justice is served to all the people, and also about introduction in fundamental duties under Article 51A.
Okay, thank you so much, Amisha. Over to you, ma'am.
Thank you, sir. Amisha, you just now mentioned that, while sir was asking, कि 20 साल हम मानते हैं life imprisonment को. Can you give me any section which says that life imprisonment is to be interpreted as 20 years?
Yes, ma'am. It is section 57, in my opinion, of Indian Penal Code.
But 57 IPC क्या कहता है कि life imprisonment को हम 20 years interpret करेंगे?
I'm not sure, ma'am. My apologies. I'll surely look into this.
Yes. बेटा जो 57 आईपीसी है वो कहता है कि लाइफ इम्प्रिजनमेंट को जब भी हमने आईपीसी के अंदर किसी भी अक्यूज को पनिश करना है और लाइफ इम्प्रिजनमेंट की उसकी फ्रैक्शन निकालनी है. फ्रैक्शन कैसे निकालनी है? 1/4 ऑफ लाइफ इम्प्रिजनमेंट. तो 1/4 लाइफ इम्प्रिजनमेंट आप कैसे निकालोगे? उसको 20 साल तब लोगे. अदरवाइज द जनरल रूल इज लाइफ इम्प्रिजनमेंट मीन्स टिल योर लास्ट ब्रेथ.
Yes, ma'am.
So like for abetment, अगर हमें अबेटर को पनिश करना है तो जो बेटमेंट की पनिशमेंट है वो हाफ होगी या फिर 1/4 होगी एज पर व्हाटएवर ऑफेंस ही हैज कमिटेड. So if he has abetted an offense for which the punishment is life imprisonment, for that if the fraction has to be taken out, it is 20 years.
20 years.
That is what 57 says. The interpretation is not 20 years for life imprisonment. Okay, beta?
Thank you, ma'am.
Yeah. And also, obiter, can you give me some example? Like, can you give me some case law where you can explain that, what is obiter and what is ratio?
I'm so sorry, ma'am. I cannot recall the case laws right now on the moment.
Okay. All right. Okay. Recently in HP, you know that a polyandry marriage has taken place. Polyandry, जोड़ीदारा marriage. कौन से डिस्ट्रिक्ट में वो मैरिज हुई है? आपको कुछ आइडिया है उसका बेटा?
Sorry, ma'am. I'm not aware about this news till now, but I will surely look into this news.
Recently in Himachal Pradesh in Hatti tribe, it's a very important, it was too much in news also, national news में भी बहुत था. Hatti tribe के अंदर there is a woman who married 2 brothers. So it was a customary practice of jodidar, polyandry. So my question to you is that, in your opinion, ऐसी जो tribal customs हैं, they are recognized legally despite their conflict with the Hindu Marriage Act 1955. Because Hindu Marriage Act 1955 does not advocate polyandry, but that marriage was given recognition, right? So what is your opinion on such traditions and customs?
Yes, ma'am. Ma'am, in my opinion, these customs, we could not outrage the customs rightly since they are from the immemorial time period, which has been followed continuously by the family. And they are going on from family to family for a long time period. Ma'am, for taking it as a valid custom, it must be ensured that it must not be immoral or against the public policy. If it is against the public policy, then that custom should be outrageously deleted and removed from the system. But if it is not, then it could prevail in the society. Ma'am, on the point of polyandry, it could be said that yes, it is not allowed under Hindu Marriage Act, but Hindu Marriage Act states that whenever there is a custom or usage in any tribes or locality, that customs or usages will prevail over the sections and provisions of the Hindu Marriage Act or Hindu law. So, ma'am, unless and until any judgment came from our Honorable Supreme Court, it could be difficult to state that we should not follow that custom directly. But if it has been followed for a very long time period, then it would be wrong to state that the custom is bad or the marriage should not be allowed. So, ma'am, till then the marriage should be allowed, until it has been recognized that the custom is against the public policy. We could not ask them to remove that custom.
But I would still recommend, Amisha, that you please look into this entire news, because this was too much. जोड़ी दारा जो अभी हिमाचल प्रदेश में ये जो ट्राइबल कम्युनिटी है, तो वहां पर इस शादी को जो है रिकॉग्निशन दी है, और कोर्ट्स ने किस तरीके का एक बैलेंस स्ट्राइक आउट किया, बिकॉज वन वुमेन टू मेन, राइट?
Yes,
सो वुमेन राइट्स, सो दैट बैलेंस हैज टू बी मेंटेन बेटा। तो उसको आप थोड़ा सा जो है प्लीज, वुमेन से रिलेटेड जो कंसर्न्स है, लाइक आपका आर्टिकल 14 एंड 15 ऑफ द इंडियन कॉन्स्टिट्यूशन हो गया, लीगल एम्बिग्विटीज होगी, किस तरीके की लीगल एम्बिग्विटीज आएंगी इस केस में, इनहेरिटेंस की, लेजिटिमेसी ऑफ चिल्ड्रन की, राइट? सो हाउ आर यू गोइंग टू बैलेंस ऑल दिस, राइट? ठीक है, तो इस केस में देयर इज दिस I'll tell you the name of the village, where this customary practice took place. This was basically in Hatti tribe, Sirmaur district mein hai ye.
Hati.
Hatti.
Ma'am, your voice is little bit low.
Hatti, Hatti tribe. It is, ye jo tribe hai, ye jo shaadi hui hai, this was, from Sirmaur district. And ये जो हाटी tribe है, this is a scheduled tribe. This is
Yes,
a
ma'am.
scheduled tribe. ठीक है? And the custom is called as Jodi Dara.
Yes, ma'am.
Jodi Dara. So please look into this. And also I asked you the name of the justice, So
Yes, yes.
yes, so you should have, whenever you are quoting, उसमें आप please पूरा जो justice, like his name is Honorable Justice Vaidyanathapuram, Vaidyanathapuram, Rama
Where
Iyer, Rama Iyer, Krishna Iyer, right?
Yes, ma'am.
Okay, all right. Can you explain res judicata, the CPC?
Yes, ma'am. Ma'am, the doctrine of res judicata is laid under Section 11 of Code of Civil Procedure, which states that when the suit has already been decided by the Honorable Court on the same matter which is directly and substantially in issue between the same parties who are litigating under the same title, then the other suit on the same matter would be barred and would not be decided and entertained by our Honorable Court.
Can you differentiate between res judicata and constructive res judicata?
Yes, ma'am. Ma'am, in res judicata is a basic doctrine where the constructive res judicata is a part of Section 11 under Explanation 4, which states that if there could be a chances of taking any defense or any raising point of law and that person doesn't raise at that moment, it would be deemed that person has refused or taken that plea, and for that plea, he could not file another suit. So fresh suit on any new plea or defense is not maintainable.
Even in constructive res judicata, it is not maintainable?
Yes, ma'am, it is not.
You mentioned that matter directly and substantially in issue. But there are some matters which are collaterally in issue. Can you explain with the example the
Yes,
difference
ma'am.
between directly and collaterally?
Ma'am, directly and collaterally means whenever any judgment is passed between plaintiff and defendant, and if it has co-plaintiff and co-defendant, but the matter which is has been also between the co-plaintiff and co-defendant, which has been decided by the court on the same matter, that would mean that the res judicata will apply on those parties as well.
Which matters are collaterally in issue then?
Collaterally, which has been dealt by the court when he was dealing with the actual issue.
Okay. Can you explain with some example?
Yes, ma'am. Ma'am, may I have a moment to think about it?
Yes, please.
Yes, ma'am. Ma'am, whenever in a civil case, the person has decided about the rights of the property into the Hindu succession property. Let's take an example. And it was raise that the person has committed murder of one person, and throughout the litigation, the court decides that the murder has.
Civil cases में अच्छा okay with respect to succession.
Yes, and the
Okay.
court and the plea was raised that the person has committed the murder, and as per the provision given under the Hindu Succession Act, the person who has committed the murder with the aim to get the property will be barred from the inheritance. If the person
Absolutely.
takes that plea and the court decides that the murder has not taken place there, and decides that the person will be entitled for the share in the property, the matter which was not directly an issue that if the murder has taken place or not, but it was decided by the court, will be the collateral matter, and the res judicata will apply on that as well, and the person could not again claim it as a trial.
Very good. Okay. Is the res judicata, doctrine of res judicata applicable to foreign judgments?
Ma'am, it does.
It applies to foreign judgments.
Yes, ma'am.
The doctrine of res sub judice applies to foreign judgments?
No, ma'am, it doesn't.
It does not apply to. Foreign judgments are directly executable here in India?
Yes, ma'am. If it is passed by the competent court by keeping all the merits and evidences of the Indian court, then it could be executable in Indian court. As per section 44A of.
No. Execution there only means the money decree. Direct execution नहीं होता है. सिर्फ money decree can be directly executed. Right? But otherwise, foreign judgments are just conclusive proof.
Okay, ma'am.
Conclusive as per section. कौन सा section है जो foreign judgments के साथ deal कर रहा है?
13. Section 13
Section
of
13.
CPC.
Yes, the first paragraph. And 13, section 14. 13 and
Jurisdiction.
14 दोनों. Yes. ठीक है? तो foreign judgments directly executable नहीं है. Okay. All right. Can you give me some difference between culpable homicide and murder?
Yes, ma'am. Ma'am, the major difference lies between the degree and intent mens rea of the person who has committed the crime. Ma'am, every murder is a culpable homicide, but not every culpable homicide is a murder. So we can say that culpable homicide is species, is a genus, whereas murder is species there.
That is okay, but elaborate the differences between
Oh.
culpable homicide.
Yes,
थोड़ा सा उसको करो बेटा.
Ma'am, when the person intend to cause the death of a person, or he knows that his act is likely to cause the death of the person, and the person dies, that would be said as culpable homicide. But if the person actually intends to
अगर
cause,
intention to cause death है, तो वो culpable homicide है. आप कह रहे हैं.
yes, ma'am. Ma'am,
तो फिर intention to.
yes, ma'am. Ma'am, that's how it is a genus and murder species. In murder, there is an actual intention to cause a death, which is similar to clause 1 of section 300 and 299
If
part
A
1.
has intention to cause death of B, he will be roped in for culpable homicide or he'll be roped in for murder.
He will be charged under murder, but if he proves that his cases comes under any of the exception, then it could be culpable homicide. So that's why section 299 as well as section 300 talks about the scenario of intention to cause the death. Another is, ma'am, if the person knows that his act is likely to cause the death, then it will be culpable homicide. But if the person is knows that his act will cause the death in all circumstances, in all probability, without any reasonable excuse, and he does it with the intention of causing death, then it will be a murder.
Let's take a situation. Let's say there's this Mr. A. He enters the hospital and he says that there's a bomb and I'm going to blast it. You have 5 minutes. सारे खाली करो hospital को. लोग भागने लग जाते हैं. ठीक है? And people in the intensive care unit are also, taken out. But in spite of it, when he blasts the bomb, there are some people who died in the hospital. What will be the liability of this person?
Yes, ma'am. Ma'am, in that scenario, the person would be charged for committing murder since his act were he was sure that by his act he would cause death of any person. The
कैसे
act was
श्योर था? उसने तो वार्निंग दिया है. उसने बोला है खाली करो.
but vacating the huge property in 5 seconds or 10 seconds was next to impossible
Not
task.
seconds, 5 minute दिया उसने. 10 minute मान लो, 10 minute दे दिया.
Yes, ma'am, I'll take it.
Intention
But
कैसे prove करोगे इसमें?
ma'am, he knew that there were a lot of people present there.
Knew means aware. Intention
Yes,
means is
intent.
intention
Yes,
intention and new intention and knowledge are the same.
no, ma'am.
What is the difference?
Ma'am, intention is a stronger degree where the person wants that
Yes.
thing to be done. Knowledge means he was aware that could happen.
So इस
Ma'am,
केस में intention थी या knowledge थी?
ma'am, in here it was a knowledge where the person wants to do that without any reasonable excuse that in all probability the death will be caused of some person. It will be a murder. But if he knew by any chance that his act would likely to cause death, then it would be a culpable homicide.
इस केस में क्या होगा?
इस case में ma'am, it will be the person will be charged under murder only.
Murder. Okay. ठीक है. All right. Can you tell me at the international level, what is your view on India's stand in Russia-Ukraine conflict?
Yes, ma'am. Ma'am, since India has been affected a lot by Russia-Ukraine war because the bad relations with the US has turned out since they have put a lot of tariff amount on India. Because India is importing oil from Russia and indirectly helping them with the money, economy, and GDP. So, ma'am, India is not completely on to Ukraine or Russia side, but India, on the other hand, has not stopped supporting the Russia by by helping its economy or GDP.
What is your opinion?
Ma'am, in my humble opinion, I would address it like uh, India is importing oil from Russia because it is the cheapest way to get the oil, and because of the Russia, now we are our economy is has the proper resources and fuels for our industries and for our economy, which helped us to grow, create employment. And it is not absolutely wrong to import oil from Russia only on the factor that they are engaged into war with some other country. So, from the Indian perspective, I would not completely outrage the act of India of importing oil from Russia, even though they are in middle of some war.
All right. Um, इंडिया का क्या रोल रहा है, एक्टिव रोल क्या रहा है रशिया यूक्रेन?
Ma'am, as far as my knowledge is concerned, I'm not very much aware about the actual role of India in between the war.
Okay, so India has consistently called for dialogues. It has called for diplomacy and peaceful resolution, beta. ठीक है?
Okay.
And it has emphasized and has respected the sovereignty and territorial integrity between the two nations. और बहुत अच्छे तरीके से balance maintain किया. And that is a strategic autonomy that India is reflecting.
Yes, ma'am.
So थोड़ा सा इस चीज के बारे में पढ़ना, right? Okay. So you are from Panipat, Amisha, right? So हिमाचल के बारे में क्या-क्या जानते हो? कितने districts हैं? कैसा वहाँ का terrain है? What all do you know about Himachal? Can you just say in few words, some few words on Himachal?
Yes, ma'am. Ma'am, Himachal is a state lies in the laps of valleys, also called as Devbhumi, very closest to the nature and have a very hilly terrains. In winters, it has snow-covered mountains. Ma'am, Himachal is a state which having 12 districts in total, wherein it has two capitals, winter and summer capital. Summer capital is Dharamshala and winter capital is Shimla. Ma'am, Himachal Pradesh is famous for its traditional clothes like Kullu shawl, Kinnor shawl, for its horticulture in like production of apples, and majorly for the tourism where the Manali is known as a famous honeymoon destination. Also, ma'am, the mountains and other terrain area attracts a lot of tourism from every part of the India. Ma'am, Himachal is a state which is famous as for its culture, religions, like the Kullu Dashera, which has been recognized by UNESCO as well. Ma'am, there are many religious temples and sites in this state.
Okay. You mentioned that Shimla has two capitals.
Yes,
Shimla is the summer capital and Dharamshala is the winter capital. ये कब बना? Do you have any idea?
Ma'am, in my humble opinion, I don't actually accurate date, but it was made because of the negative temperature in Shimla during the winters, because it was very difficult to conduct the assemblies during those snow-covered roads. And to save that hustle, the Dharamshala was made the winter capital of Himachal.
Good. ठीक है. Also, Amisha, you mentioned that Himachal में tourism बहुत है, right? But do you know that tourism जो है, it is the backbone of HP? You agree? हिमाचल प्रदेश का जो tourism है, that is the backbone. किस चीज का बैकबोन है? वो हिमाचल की इकोनॉमी मेनली जो है टूरिज्म पे ही चलती है बेटा, ठीक है? बट इट ऑफन कम्स एट द कॉस्ट ऑफ इकोलॉजिकल बैलेंस. You can see a lot of environmental destruction. So, in your opinion, how should the judiciary intervene to ensure sustainable tourism in Himachal Pradesh?
Yes, ma'am. Ma'am, in my humble opinion, every rose has its thorn, which means that if anything gives you good thing, then it also comes with some price. Similarly, ma'am, Himachal is a beauty which attracts a lot of tourism, but on another hand, it gives degrading effect to our environment in a long run. And that could be seen by the natural calamity and disaster, which was somewhere because of the human intervention. Ma'am, for the smooth traveling of the travels, huge amount of mountains are being trimmed out, being blasted, and tunnels have been made. So, ma'am, that was the bad effect of the tourism. Ma'am, from the perspective of judiciary, I would suggest some suggestions like keeping track on and keeping a tab on amount of tourists visiting HP at the moment. We could limit the amount of travelers, like it should not be overcrowded, which gets during the period of holidays. There should be a proper transparency and accountability of all the amount of tourists which travels. Also, ma'am, as it can be seen that in Himachal there are a uh, lot of regulations, like you cannot throw garbage anywhere, and if you did, you may be charged with the fines. So, ma'am, such kind of regulation should be more stricter to control those actions, like polluting or littering garbage.
Judiciary के क्या tools and approach होना चाहिए बेटा?
Ma'am,
What should be the approach of the judiciary and what tools should judiciary, use? कि ये जो ecological balance disturb हो गया है, इसको सही किया जाए. क्या कर सकता है judiciary?
ma'am, judiciary could ask and make regulations which could limit the amount of tourists visiting Himachal.
Judiciary का काम है regulations बनाना.
No, ma'am, not really, but it could direct to the state government, or uh, it could have some program which could make some suggestions in that.
Can I put it like this, Amisha beta, कि हम उसको कह सकते हैं कि judiciary can take suo motu cognizance.
Yes, ma'am.
है ना? Instead of
Yes,
making
ma'am.
regulations, but
Can
yes,
can
it
make
can take suo motu notice ले सकता है, take notice of the environment degradation in tourist areas. That's one. Okay. Second.
Ma'am, second, the judiciary, if any, as per the Environmental Protection Act and as per the many Forest Act or Wildlife Protection Act, the judiciary has the power and authority to pass the regulations in consonance with those acts, with the aim of protecting the environment, and direct the government to have some stabilizing and balanced approach to prevent the degradation of the environment. Also, ma'am, as per in Himachal Pradesh, various regulations like Himachal Pradesh Tourism Regulation Act is there, under which the regulations could be stricter, and the judiciary could even pass some directions to assist those act and to implement the execution, to implement
Do
those
you
acts.
know do you know this principle, polluter pays principle
Yes,
in
ma'am.
Himachal? वो आप उस पे बात कर सकते हैं, ठीक है?
Yes, ma'am.
सस्टेनेबल
And
डेवलपमेंट के प्रिंसिपल्स
precautionary.
की बात करें, आप PILs की बात कर सकते हैं, right?
Yes,
And
ma'am.
धर्मशाला जो है बेटा, it was made the capital in the year 2017. I was just
2017.
I was recalling
Yes.
the year.
Yes.
2017 में जो है, it was officially declared as a second capital. 2017 से पहले हिमाचल शिमला ही था जो उसका capital.
Shimla is zone.
Yes, yes. Dharamshala, do you know any famous person to whom Dharamshala is the home
Ma'am, Dharamshala is very
of?
closest to McLeodganj, and herein there was a Dalai Lama
Yes,
who
very good.
moved from Tibet.
Yes, yes, yes. So basically, Central Tibetan administration, it is making it globally recognized as a spiritual center for
Yes,
the
ma'am.
Tibet community. Okay, can you tell me why, what was the need to repeal IPC, CRPC, and Indian Evidence Act and was being replaced by BNS, BNSS, and BSA? Was it a
Yes,
good
ma'am.
move?
Ma'am, since those acts were prevalent through the British colonial era, and now the society has developed a lot and moved a lot from that period. It's been a long time since that act was passed. The terms like queen, crown is not used nowadays, which was like a neglected portion of that act. Also, ma'am, there was a
IPC में use करते थे हम crown.
ma'am,
IPC में हम crown word use करते थे.
ma'am, crown word was mentioned into Evidence Act, but not in IPC. IPC mentioned the word queen there.
Evidence में कहाँ mention था crown?
Ma'am, as per as my knowledge is concerned, section 57, 57 mentioned about when there is a thing of taking judicial notice. And ma'am, also when it was about the raising presumptions.
Okay, so if I see section 57 of the Indian Evidence Act, the court shall take judicial notice of the following
Yes,
fact: all laws in force in the territory of India, all public
yes, ma'am.
acts passed or hereafter to be passed by the Parliament of UK, and all local and personal acts directed by Parliament of UK. Okay. Articles of war for the Indian Army, Navy, or Air Force, the course of proceedings. Okay. ठीक है, in clause 6. Clause 6. Okay. All
Yes,
right.
ma'am.
So is this section completely repealed by BNS
No,
57?
ma'am. No, ma'am.
How it
Yes.
has been changed? Now, is it changed or is it repealed?
Ma'am, we could not say it as a repeal, but we could say that the BSA is the new form of the Indian Evidence Act, which missed mentioning those words which are not useful in today's era. Other than that,
Mhm.
ma'am, the major reason is the technology advancement in our society, which requires proper regulations. Also, ma'am, earlier there were a minimal amount of punishment and fine amount were stated into the act, which are highly negotiable amount in today's time period. So there was a high demand to change those. Also, ma'am, it has been noticed that the community service clause has been added into the new act, which is useful for the society as well as arises and states that it is focusing on rehabilitating on the accused as well, and it is serving both the victim and accused on the same page. Rather than just only punishing the person, they are working on serving nyaya to the people, working on from the perspective of victim as well as hearing the accused properly. Just like as in these, we can notice that under the complaint procedure, which is before the magistrate, it is now compulsory to serve the accused notice before lodging the complaint, which is highly reliable on the maximum of audio ultram partem. They are following now the proper rules of natural justice, transparency, accountability, and serving the people with the justice and being the victim oriented acts.
In your opinion, it was a good move?
Yes, ma'am. Absolutely, it is.
It has shuffled all the sections. Are you okay with it?
Ma'am, it doesn't shuffle it, but I would like to mention that they reorganized in a better position. Now we
Very
could access the if we take it Bharatiya Nyaya Samhita, we can access all the provision related to women and children under one head only. Earlier it was segregated, which was maybe somewhere difficult to point it out. Now they have made it more organized.
last question from you, then over to Sir. Yes. So if there's a young accused in a theft case and he's found guilty by you in the court, and he's very young and he comes from a very humble background, okay, what considerations would you keep in mind at the sentencing stage?
Ma'am, there is a provision of Section 360 CRPC and also the Provision of Offenders Act, which states that it is not compulsory to punish the person at the first instance only. But the major duty and discretion of the court is to do justice as well as to rehabilitate the accused when there are chances of that. By keeping in mind the character of the accused, age of the accused, the nature of the offense which he has committed, earlier instances, the court could release the person on probation or by just admonishing him, like by scolding him and trying to rehabilitate him. The court could release that person, and uh, it is not compulsory to punish the person at the first instance only.
Even in spite of his theft being proved, can you release him without the punishment, when Misha?
Ma'am, I couldn't hear the case. Theft of?
So there's this young accused, he's been charged and proved guilty of theft, but he
Yes.
comes from a very humble background.
Yes,
He
ma'am.
comes from a humble background. So
Ma'am.
what all factors you will keep in mind while sentencing him?
Ma'am, if the amount of theft doesn't exceed 2,000 rupees, then he could be released at that moment, as stated under Section 360 of CRPC only. Also, ma'am, by stating that by the nature of the offense and by character of the accused, the court has the power to release a person. The victim person could be compensated by the acts of because of the acts of the accused person.
आप जो है मतलब लीगल प्रोविजंस ही कंसिडर करेंगे ना?
Ma'am, I'll balance.
What is sentencing? What is sentencing in your opinion? When you have to sentence an accused, what is it? What is sentencing? Is it punishment?
Ma'am, sentencing means ordering for the imprisonment. Sentence
वही मैं कह
is
रही
a
हूँ
type
कि
of
punishment.
imprisonment which the person suffers into the prison jail.
Can we say that sentencing is a balance between justice, reformation, rehabilitation,
Yes, ma'am. It
or it
is.
is only punishment?
No, no, no. It is a motive to rehabilitate the accused person.
Yes. Okay. And then while sentencing, you will always consider age. You will consider the crucial background, and then you will proportionally sentence the accused.
Yes, ma'am.
So जभी भी आप सेंटेंस करेंगे अक्यूज्ड को, सो कुछ की कंसिडरेशंस होते हैं जो हम लोग माइंड
Yes,
में
ma'am.
रखते हैं, राइट? सो माय क्वेश्चन वाज फ्रॉम दैट एरिया, राइट? So
Yes,
we are going
yes.
to keep the age, the youthfulness, the
Yes, ma'am.
socio-economic background, and accordingly we will charge him and sentence him.
Yes.
Okay, thank you so much, Amisha. Amisha, if you have any question for us, please ask.
Ma'am, I guess I got all my answers in between the interview only. Thank you so much for the clarification.